Right. Shall we start? Right now, I think last time we have discussed about the prospectus and capital. And today we can go to winding up of the company. And winding up. This note is uploaded to the LMS, right? Right now, uh, another very important topic. Winding up is end of the company, right? So after the winding up, then the existence of the company is ceased, right? No longer existing. So we are discussing how we can wind up the company, right? Now, when we consider the concept persons, right? In my I think the first topic under incorporation we have discussed there are two types of persons, right? Natural, legal. So under corporate law, actually we are discussing how to incorporate a company under the Companies Act, right? So natural person, when we consider human beings or the natural persons, they will die. Right? One day they will die. But as far as concerned legal persons, they are artificial legal persons, created persons. Then actually, generally they have perpetual succession. Right? So that is mentioned here. Generally they have perpetual succession. Right? That is, this legal person can exist until and unless winding up steps are taken. So, perpetual succession. That is, generally they have, right? Right. So the perpetual succession means they can exist for a long period of time, right? Or they will never die. That meaning, right? That is the meaning. So we can say unless and until winding up steps are taken, they can exist. Right? So there is the meaning of perpetual under parenthood. Right? Under parenthood. Right? So that is the meaning of this. Right now, actually now when we consider the winding up, here we have to adapt particular process. There is a process. In this process, very simple. There is now in order to wind up the company, first we have to collect all the assets of the company to be collected and realize them, sell them, right? Then out of the proceeds, we have to settle the creditors, right? First, the priority to be given to the creditors, right? Then thereafter, we have to pay the winding up expenses. Then, after paying creditors and winding up expenses, any amount remained in the company that is named as surplus assets. Surplus assets, right? Then surplus assets to be distributed among the members of the company. So this is the procedure, right? Very simple. First, uh, we have to collect the assets, then sell them, realize them, and out of the money, we have to settle the creditors and winding up expenses. And after paying those things, if any amount remained, it is known as surplus assets to be distributed among the members. So this is the procedure. Right. So here actually it is mentioned companies are legal personalities and they have perpetual succession. And Thereafter it says their existence cannot cease as of human being, right? There may be specific several reasons for the existence of a company is to be ceased. The end of the company comes when it is dissolved. That is the end of the company. After dissolution, there is no company existing, right? Winding up or liquidation is the process that prepares the company for dissolution. In this process, the assets of the company are collected. Let the first step realize, right? Sell them. Right? The process of such realization are utilized to settle the debts. Debts means creditors. We have to pay the creditors of the company, and not only creditors, actually winding up expenses also to be paid. Then thereafter, any balance remain after meeting yes, expenses. Yes. Any balance remain, any balance that remains after meeting the expenses of the winding up is distributed among the members of the company. So remaining amount is known as surplus assets. Surplus assets, right? Then since companies are legal personalities, their winding up is regulated by law. Right? Winding up of companies is regulated by the Companies Act and winding up rules 1930. Now here 1930, these rules introduced under companies ordinance. There are three enactments in Srilanka. First, Companies Ordinance, then Companies Act, right? Number 7 of 82, no? 1982, number 17 of 1982, and the prevailing Companies Act. This is number 7 of 2007. व्यवस्था तुरंत कैला भी ना था believe मतलब the आज्ञा करता this ordinance that is prior to independence before 1948 so rules are introduced under that ordinance so still in force because 530 of the Companies Act says the rules introduced under the previous ordinance or the amendments are still in force unless they are repeated or amended, right? So they are still in force, right? So even though it is introduced under Companies Ordinance, still in force, right? The winding up rules 19 will apply to winding up by court and subject to supervision of the court. That is the procedure, right? So when we consider the modes of winding up, actually we can identify there are three modes. By three ways we can wind up a company. The first one is by court, right? Or it is known as compulsory winding up, right? And voluntary and subject to supervision of the court. There are three modes we can identify, right? Court, voluntary, and subject to supervision of the court, right? So out of these, actually, the most important method is by court, compulsory winding up. In so here you can identify next heading. It says winding up by court. This is also known as compulsory winding up. So both are same, right? Winding up by court, or we can say compulsory winding up. Right. And thereafter, some facts actually mentioned there. Right. So before consider these facts, right? I come to that later on. First, we consider about the procedure in a summary way. Then thereafter, we can go through the queue, right? Handout, right? And now, when we consider the winding up by court, very simple, right? Very easy to if you remember, right? Suppose this is the timeline. Right. Now, in order to wind up a company by court, Right? The first step is filing a petition in the court of law. Petition along with an affidavit. Petition and affidavit to be filed. Now, suppose they file petition and affidavit on 1st of January. So this is the date on the filing of the petition. Petition, not only petition, along with an affidavit. Now, affidavit means actually we are giving evidence, right? So by way of this affidavit, we are giving evidence. Understood? Right? Petition and affidavit to be filed. So not only the application, so application is the petition, and along with the application, we have to give evidence as well, right? Petition and affidavit to be filed. Right? Now generally, right, the court case, like suppose A and B engage into a contract, right, contract, and suppose B breach the contract, then I think right, A is entitled to file an action against B in order to recover damages. Right? In general, right, way, in order to recover damages, A can file an action against B. So here actually A has to file claim. Claim. Right? Claim. Application is known as claim. Right? We want to file an affidavit. Claim. Then thereafter, what happened now A filed an action against B, then A is known as plaintiff. Plaintiff. Then the other party to the action is known as defender. Then after claim, right? So application is made by way of the claim to be filed. Then the other party to the action or the defendant, then thereafter he will file answer. Answer. Well, claim and answer. So these are the main documents to be filed by parties to the action, general action, right? Then after claim and answer filed, then the matter will be fixed for trial. Then trial. So at the trial, you can produce the evidence. Right? This, at the trial, actually, the main purpose of the trial is taking evidence from both parties, plaintiff and defendant. Right? So evidence. Then after considering the evidence, then court can reach to a decision. That is known as judgment. So this is the regular procedure. Right? They answer. Then here we can get evidence at the trial stage. Right? Oral evidence or documentary evidence, whatever the evidence can be taken in the trial stage. Right? So that's the way. And then after that, the decision right, can be given. That is known as judgment. So this is the way. But here actually we can identify petition. So we have to make an application for by way of petition. So here the person who filing the petition is known as petitioner. Petitioner. Petition. And the other party is known as the respondent. With the company or whatever. The other party is known as respondent. That's it, right? Petitioner, respondent. Right. So once he is filing the petition, along with that, he is giving evidence by way of an affidavit. Right? By way of an affidavit. Right? Then Right, so that is the difference, right? So petition along with an affidavit, application to be made to the court. Right, then, right. Now that petition is filed on 1st of January, right, along with an affidavit. Right. Then what happens? Once the petition is filed, then court will appoint an officer. Right? This officer is named as official receipt. Right? Official receipt. Right? Court will appoint an officer. Right? We name this person or the officer as official receipt. He is an officer attached to the court. Right? Court officer is appointed as official receipt. Right? Reason is why the court will appoint official receiver. Right? As the official receiver, court officer is appointed by the court. Reason is now the petition is filed in order to wind up the company. Right? Then after the petition is filed, right, allowing the directors or the shareholders to monitor the affairs of the company, it's a risk. It may be badly affected to the creditors. Therefore, in order to displace the directors, in order to displace the powers of the directors, court will appoint court officer as official receiver. Then what happens? This person, right, will conduct or monitor the affairs of the company, right, for a short period of time. Or we can say actually, he will monitor the affairs of the company until the winding up order is given. Right? So for that short period of in order to control the affairs of the company, right, and displace the directors, right, the board will appoint board officer, right, the name is officer as official receipt. Official receipt. Right, so the reason is why not we actually court will appoint this official receiver in order to displace. Displace the directors. Right? So giving control to the directors may be harmful to the creditors. That's why displace the directors and give the control to the independent party. Actually, court officer means independent party. Right? So only thing is his name is we name this position as official receipt. Understood? Right? Then what happened? Official receiver. Right? Then we will consider the next step is, right, by virtue of his office, official receiver, this person is being appointed as the provisional liquidator. Provisional liquidator. Same person, right, by virtue of his office. Right? So it means by being the official receiver, by holding this position, this person is automatically appointed as the provisional liquidator. Provisional means again for a short period of time, right? As a liquidator, he will be appointed by virtue of his office. Again, now the president by virtue of his office, he will be the commanding officer of the three forces. Well, by virtue of his office. ඒ මතම එයා හරි අපි අනුමන provisional liquidator. So actually these both official receiver and provisional liquidator are that same person, right? So same person appointed as the provisional liquidator, right? Right. Thereafter what happened? Some time after, right? Then what happened? Actually, two things may happen. After considering the petition and objections, other part has to file objections. Respondent. After considering the petition and objection and the evidence given by way of affidavit, the court can dismiss the petition. Right? One thing is, right? One thing may be happen, that is dismiss the petition, or court can give a binding up order. Right? You can say, so here the binding up order is given by the court. Binding up order. Binding up order is given on 31st January. Binding up order is given. So whether is this, then nothing to say, right? But binding up order is given. Suppose binding up order is given on 31st January. Right? Even though the binding up order is given on 31st January, the effective date of the binding up order is, right? That is filing of the petition. Right? Effective date to be treated as the date on which petition is filed. Right? So if now here the 31st of January, binding up order is given by the court, but effective date of this binding up order is treated as the date on which the petition is filed by the petitioner. Right? That is 1st of January. From here, it is valid. Binding up order is valid from the beginning. Right? Binding up order is effective from the beginning. Right? That is from the date of filing of the petition. Binding up order is valid. Right? Why? The very important thing here, the effective date is very important. Reason is during this period, that is from filing of the petition and giving the binding up order by the court, during this period, suppose the company has sold its assets, transferred or disposition, or made alteration to the position of the directors or shareholders or the shares. All the transactions to be treated as void. Understood? Right? All the sales, right? Sales, transfers, dispositions, alteration made to the position of the shares to be treated as void. Null and void. No value. No value. No value. Right? So during this period, all the transactions to be treated as void. Invalid. That is the meaning. Null and void. Or we can say void means null and void. No any legal effect. Right? Then what happened? After the binding up order is given, the court will appoint liquidator. After the binding up order, we can identify court will appoint liquidator in order to perform the liquidation process. Right? Liquidation process. That is collecting assets of the company, realize them, setting the creditors, expenses, and distribute the surplus assets among members. Right? In order to perform this binding up process, right? Liquidator will be appointed by the court after the binding up order is given. Understood? This is the procedure. Then here some additional features we can recognize. Now, official receiver, I told you, is an officer of the court. An officer of the court. Then one official receiver is appointed. Actually, he has two duties. Right? There are two duties, task on official receiver. The first one is he must obtain a statement from the directors. It is known as statement of affairs. Statement of affairs. Statement of affairs. So according to the statement, actually directors must reply to the official receiver stating what are the assets, liabilities, name and addresses of the creditors, what are the charges owed by the creditors. So all these particulars to be submitted to the official receiver. So by this form or statement, official receiver has to take this statement from the directors, generally to be given by the directors, right? And the second duty is, now we can identify the company, we can identify members and creditors. Right? Members are known as contributors. Another name can be given to the members. Members means shareholders. But instead of shareholders, we can say members, because in some companies, no shareholders, no share capital. Now, if it is a company limited by guarantee, then no share capital. Therefore, no shareholders, no shares, right? Therefore, no shareholders, then we can make them as members of the company, right? So members, or here actually we can name them as contributors. Contributors means the persons who are responsible to contribute to the assets of the company in the event of liquidation. They are the members of the company, right? They are the right directly out of members. They are the members. Like you can say shareholders. They are the shareholders. That contributors. Right now, the second duty. What is the second duty asked for official receiver? That is, he must summon means call. He must call two separate meetings of contributors and creditors. Two separate meetings of contributors and creditors. Two meetings to be called. Right? Two meetings to be called, contributors and creditors. Right? The reason is, now here, after the winding up order, liquidator is appointed by the court. Right? Now, actually, the official receiver, he, right, by being that the official receiver, he, until the winding up order, he is treated as the provisional liquidator. Right? Then after the winding up order, court can appoint liquidator. Right? This person, this what we call that position is known as liquidator. Right? Liquidator. Now, why official receiver calls for separate meetings? Right? In order to decide who to be appointed as the liquidator, whether official receiver or another person to be appointed as a liquidator or not. In order to decide that, right, two separate meetings to be called in order to get consent of the these contributors and creditors. Right? Why two meetings called? In order to decide whom to be appointed as the liquidator. Right? And say yes, in order to decide the appointment. Appointment of the liquidate. Appointment of the, in order to decide the appointment of the liquidator. Again, this person, if there is no objection from the contributors and creditors, official receiver can be appointed as the liquidator of the company. So, in order to identify whether any objection for the official receiver to be appointed as the liquidator, who he needs to be put. And the second the reason is for the two details, there is appointment of the another committee. It is known as Committee of Appointment of Committee of Inspection. Committee of Inspection. This committee is known as Committee of Inspection. That's all. Committee of Inspection. Appointment of Committee of Inspection. Right. Now, when we consider the Committee of Inspection, this is a committee that consists of small number of shareholders. You can say instead of shareholders, contributors and creditors. This committee is consists of small number of contributors and creditors. Right? Their main duty is support to the assist to the liquidator to inspect and certify. Certify the accounts of the company. Right? For that purpose, this committee is appointed. Right? Inspect and certify the accounts of the company. So that is the main duty of the committee of inspection. Right? They need support to the liquidator to inspect and certify the accounts of the company. Right? So for that purpose, right, in order to decide how to appoint the committee of inspection, two separate meetings to be formed. Understood? So this is the compulsory writing. Right? So first we can identify petition along with an affidavit file and official receiver, the post, right? Is known as official receiver. Right? The same person will be appointed as the liquidator. Winding up order is given. The effective date of the winding up order is the date on which petition is filed. During that period, any transaction with regard to sale, disposition, transfer, or maybe any alteration to the shares issued by the company to be treated as void. Then after the winding up order, the liquidator will be appointed, right, in order to proceed the winding up process, right? And here the official receiver, he has two duties, right? He has to obtain statement of affairs, right, and the two separate meetings of contributors and creditors. The reason is in order to decide the appointment of the liquidator. Official receiver or another person to be appointed as the liquidator or not. So you don't decide that, right? And the second reason is appointment of the committee of inspection. This committee is right appointed in order to inspect and certify the accounts of the company. Actually, they are like support to the liquidator, or assist to the liquidator to inspect and certify the accounts. Right? That is the main duty of the committee of inspection. Right? That's all. This is the procedure. Right? So, what we are going to do, it's a book about the procedure. Right? First person, another job title, professional liquidator, and liquidator. Like why we appoint the official receiver, reason is right in order to appoint independent person to monitor the affairs until the winding up order is made. So I mean, then they try to do that. In the Lanka, right? And I got the jacket of the creditors. These are the independent party. appointment of the liquidator. So if there is no such objection, in order to this person be appointed as the liquidator, then what happens? After considering the nomination at these two separate meetings, court will appoint the official receiver as the liquidator. Or we can say actually, official receiver will act as the liquidator. Same person will be appointed. Even though there are three positions, same person may be appointed. Yet the same person is the appointed. Right? Official receiver, provisional liquidator, same person will be appointed as the liquidator. Right? And how to work it right here. Kalau kita ada apa pakai sama lagi. Kan? This is that. Baik, kami bukan kita foto desain atau kalau mau jadinya patahan kita itu ini kayak itu. Right. So there are three modes we can identify. Winding up by code. In order to wind up a company by code, an application should be presented to the court by way of petition. Grounds for compulsory winding up. The company may wind up by code if the company has resolved special resolution to wind up by code. Here actually special resolution, shareholders can pass a special resolution as to wind up the company by code. Then it's a ground for a compulsory winding up. The company does not commence its business within 1 year from its incorporation or suspended its business for 1 year. Another ground, right? And the number of members falls below that the statutory minimum number. So what is the minimum number of company? Minimum number of shareholders? Yes. Minimum number of shareholders. Minimum, what is the minimum number of shareholders? It is? Yes. Minimum number of shareholders. Generally, right, at least company shall have 2 shareholders. 2 shareholders. 2 shareholders. But I came to 1 like however, according to section 4 subsection 2, right, according to section 4 of the Companies Act, it says, right, according to the section 4, single shareholder companies are permitted. Single shareholder. Single shareholder companies are permitted. Right? So the single shareholder, right? Single shareholder may be, right, secretary to the treasury. Secretary to the treasury. On behalf of the government. On behalf of the government. Single shareholder may be the secretary to the treasury. Secretary to the treasury, he represents the government on behalf of the government. Single shareholder. And further, the section says the single shareholder may be a body corporate. Body corporate. Body corporate means another company, right? Another company or an establishment which is incorporated by an act of the parliament, right? So company or any establishment incorporated under an act of the parliament act, right? we have discussed that like legal persons, we can create legal persons by two methods. One is under incorporation, uh, right? By incorporation under the Companies Act. This is the first one. This is what we are discussing here, right? And the second one is Parliament can bring an act declaring a particular establishment as a legal person, right? Like you see. Foreign Employment Bureau, right? So these are some establishments that are created by an act of the Parliament. And the further it says body corporate or an individual. So single shareholder may be secondary to the treasury, a body corporate or an individual. And so single shareholder companies are recognized under Section 2. Generally, two shareholders, right? Special locations we can identify like this. Single shareholder companies can be incorporated. Here, an individual means natural person. Any natural person may be a single shareholder. Therefore, actually, this is the rule and exception. Therefore, we can say actually the minimum number is 1. Usually, because of this provision, we can say a single shareholders are not. So, if it is less than, other than this, right, the minimum number of shareholders less than the required amount, then it's a ground for a compulsory liability, right? So, then no directors. If there is the company has no directors, then there's another ground. And in the last two, they are very important, right? The company is unable to pay its debts, right? Unable to pay its debts, and court is of opinion that it is just and equitable to wind up the company, right? Unable to pay its debts, right? Another very important area, right? Meaning of inability to pay debts, right? Section 271. Right. So actually, under this section, 3 occasions recognized. Right. Here it says the company shall be deemed to be unable to pay its debts under the following circumstances. Right. Then the first one it says, if the company indebted to a creditor a sum exceeding 50,000 rupees, right? And who demands the payment in writing, right? And the company has neglected or failed to pay the sum to the creditor within 3 weeks from the date of such demand, then it deemed that the company unable to pay its debts. So here 3 conditions to be fulfilled. Like under first instance, it says the company owes money to a creditor more than 50,000 rupees. More than 50,000 rupees. And the second condition is creditor must demand the money in writing. Demand. There shall be a written demand. Then within 3 weeks' time, if the company unable or neglect to settle the money in full, then it deemed that the company unable to pay its debts. Right? So then what happened actually? That creditor can make an application to court for wind up the company. Right? So this petitioner may be the creditor. Creditor. He can make an application to court for compulsory liability. Then after compulsory binding up, what happened actually collect the assets of the company, realize and settle the creditors. Right? By that way, he can recover the amount. Right? So he can make an application to also compulsory binding. So these three conditions to be fulfilled. The amount to be more than or exceeding 50,000 rupees, and the creditor must make a written demand. Written demand. In writing, he must demand the money, and within 3 weeks' time, company neglect to pay, right? For the default payments, then he can make an application to go for finding of the company. Then there's uh, another ground is mentioned here. If an execution order, right, of a court in favor of a creditor of the company is returned unsatisfied in whole or part. Another ground for compulsory binding. Or another ground for that the company is deemed that unable to pay its debts. Execution order is returned unsatisfied. Whole or part. Right? Another ground. Right? That is now here execution order. Right? Another concept. Execution order. Now, when we consider the meaning of execution order, there is like this. Now, suppose A and B, right? So, suppose this company and A engage into a contract. And company has violated the terms of the contract, breached the contract. Then, as the innocent party, this person file an action against the company. Right? According to the judgment, right, A court held A is entitled to recover 1 million rupees from the company. Right? Then after the judgment is given, actually we can name these two parties as judgment creditor. A can be named as judgment creditor, judgment debtor. Creditor and debtor. Judgment debtor, judgment debtor. Right. So according to the judgment, company has to pay 1 million rupees to creditor. Judgment. Right. Now, if the company defaults in payments of 1 million rupees even after the judgment is given, then what is the next step? These are දුන්නට පස්සේ සමාගමට විරුද්ධව තමයි තීන්දුව දීලා තියෙන්නේ. සමාගම කිව්වේ නැත්තම් ඒවට සල්ලි දෙන්නේ. Suppose the company has no money to settle the 1 million rupees. Then what is the step? Yes, how judgment creditor can recover the money? Yes, that is the way, right? So here judgment creditor can ask for an execution order. That is known as execution order. Execution order. Right? Execution order means, right? This is an order given by the court to seize the assets of the company, and sell them in the public auction and recover the amount due to the judgment creditor. So by that way, right, the court can execute the order. ක්‍රියාත්මක කරනවා කියලා තීන්දුව ක්‍රියාවේ යොදවනවා. execute කරනවා. එහෙම තමයි කරන්නේ. නොපෙන්නේ කොහොමද අපි වුණත් එහෙම අපි ණයක් කරා ගිහින් නැත්තම්. හරි? අපි තීන්දුවක් දෙනවා ඕනෑම ගෙවන්න ඕනේ මුදලයි පොඩියයි මෙච්චරක් කියලා. ඒත් අපිට ගෙවා ගන්න විදියක් නැත්නම් ඊගාවට තමයි අර බැංකුවක් මොකක් හරි ක්‍රෙඩිට් එයාට පුළුවන් එක්සිකියුෂන් ඕඩර් එකක් ඇප්ලයි කරලා ගන්න. එක්සිකියුෂන් ඕඩර් එකක් ගන්න පුළුවන්. ෆිස්කල් කියලා ඉන්න නිලධාරියෙක් සාවි. එයා ඇවිල්ලා එයාගේ ගෙදෙට්ට ඇවිල්ලා තීර දීලා ඒවා තහනම් කරනවා. සීස් කරනවා. උපුරවල මේස ජාවාවේ ඔක්කොම යටි පාඩ ස්ටාන්ඩ් දෙකේ තහනමකට කරනවා සීස් කරලා මොකද කරන්නේ වෙන්දීසි යක් කැඳවල වෙන්දීසි විකුණු විකුණුනේ මුදලා ඒක කරගන්න ඒක තමයි කරන්නේ ඈ අපි රස්සාවක් කරනවා පඩියෙන් එකයි කරගන්න මොකද 500 කියන විසු ප්‍රමාණය සීස් කරනවා 500ක් විතරක් යාට දෙනවා ඒක අයිගාස්සේ කියනවා අනිත් එක ඔක්කොම කපා ගන්න දුන්න හැම මාසෙක අර තීරණය කරා ආද බැලුව ඒකේ අර ස්ථිර රැකියාවල් හේතු කරනවා ගන්න කරනවා ඒගොල්ලන් නායකයෝ අපේ කරනවා යෝටායික්ස් අනිත්‍යවලදී විකාව කරන්න හරි අප්ලීස් ඕලෙලා මේක නොකියවන්නේ නැත්නම් ඕවා කියනවා පාඩිය නැත්නම් මෙතන මේකේ 1970 ගණන් වල ආපු නීතිය ඒකේ හැත්තේ අපේ ජීවිතය ඒ කාලේ රුපියල් 500ක් යාට දෙනවා. රුපියල් 500ක් කියන්නේ ඒකට ඊට තමයි ඉතුරු කපා ගන්න. රුපියල් 500ක් කියන්නේ සෑහෙන මුදලක් දීලා. අපිට ජීවත් වෙන්න පුළුවන් කියලා කියලා කියන්නේ මේ කාලේ. ඒවත් ඉතින් වෙලා නැහැ ආම 500ක්. 500ක් තමයි. ඒකවල 500ක් කියන්නේ පරිවර්ත පරිගත්තා රුපියල් 2000 3000 පඩි කරලා අරන් ඉතින් 500ක් යාර දෙනවා ජීවත් වෙන්න මාසෙක ඉතුරු කපා. ඒක අරමුණ වෙලා තියෙන්නේ ඒක කොහොමද ඒක 500 බාර දෙලා කියලා ඒක වෙනස් වෙනවා ජීවත් වෙන්න. Anyway, so there is the execution order. Now, what happened here? Execution order unsatisfied. Whole or part. That means, right? It is written unsatisfied whole or part. It means actually the company has no sufficient assets in order to meet the execution order. That's why it is written. ඒ ආපහු යන්නේ ඒකයි. දැන් ඇවිල්ලා බලනකොට මොකුත් නැහැ වෙන්නේ. තහනම් කරන්න දෙයක් නැහැ. ඒක මොකද දැන් ණය කරගන්න දෙයක් නැහැ ඒකයි. Right? Returns unsatisfied, right? Whole or parts. මොකද කොටසක් විතරයි අය කරගන්න පුළුවන් නේ. අනිත් ඒවා අය කරගන්න. It's like being that the company unable to pay its no assets, no sufficient assets to meet the execution. Right? So there is the another ground for another reason that we can treat as the company unable to pay its debts. Right? Then thereafter it says it is true to the satisfaction of the court that the company is unable to pay its debts due to contingent and prospective liabilities of the company. Prospective liabilities, future liabilities. Contingent or prospective liabilities, company unable to pay its debts, then to be proved to the court, right? So we have to satisfy the court that the company unable to pay because of these reasons, right? Contingent or prospective liabilities. Then we deem that the company unable to pay its debts. Then grounds for winding up just and equitable. There are two reasons actually earlier we have mentioned. That is, company is unable to pay its debts. And the court is of the opinion that winding up is just and equitable. Right? So that is about here. Grounds for winding up is just and equitable. Right? Here actually the court will decide whether it is just and equitable. Right? So some reasons are mentioned here. The main objective of the company is completely achieved. The main objective is completely achieved or impossible to achieve or fraudulent. The court may decide winding up is just and equitable. Right? And the company is a bubble. It means it does not have any asset or any business. right? After incorporation, the company has no any assets or any business. It's a bubble because someone hold that. So the court can decide winding up is just an equity. Then who may make an application to wind up the company by court? Right? So these persons can make an application. The company itself, by passing special resolution at the general meeting, the company can apply for compulsory winding. Right? The company itself and any creditor or creditors, right? Creditor can make an application to recognize that, right? If the company unable to settle that amount within 3 weeks time, right? Then the creditor can make an application. Contributory shareholder, they can make an application. Here it is mentioned, contributory means shareholders and any other persons who are liable to contribute to the assets of the company in the event of liquidation. If we consider like company limited by guarantee, right? In that type of companies, we can identify members, no share capital, therefore members have undertaken to contribute to the assets of the company in the event of liquidation. That in an amount mentioned in the articles of association, right? In our topic articles we have discussed this, right? So they are, so in that company we can name them as members. So altogether shareholders, so the persons who are responsible to contribute to the assets of the company are known as contributors, right? Official receiver, right? And register of companies. Register ROC, you can make an application to wind up the company. Official receiver, right? He can make an application of his first after filing the petition, he is appointed. Right? He can decide, like in order to wind up the company by court or not, right? So another person is recognized as official receiver, right? Then the commencement of the winding up. Commencement or the effective date is the date on which filing of the petition. That's another important thing that we discuss here. Section 277 provides that the winding up of a company by court shall be deemed to commence from the date of filing of the petition. So that is the effective date of winding up court. Therefore, the winding up commences not from the date of winding up order, not from the order, right? Of the not from the date of winding up order of the court. It is from the date of filing of the petition, right? So that is the effective date of the winding up. The consequences of winding up order. Then what happened after the winding up order is given? The copy of the winding up order must be sent to the register of companies. Right? Copy is sent. No action can be proceeded against the company except the leave of the court. And now here it says, now after the winding up order is given, liquidator is appointed. Right? Then now suppose the third party goes to file an action against the company. First, that third party must get leave from the court, right? Permission from the court. And if the court permitted to file an action, then actually the third party can bring an action against the, not against the company, against the liquidator. Understood? Once the liquidator is appointed on behalf of the company, then the actions to be filed against the liquidator. Now, suppose the company has to file an action against another party, right? Company is going to file an action against another party. On behalf of the company, liquidator will file an action. It is known as liquidator is entitled to sue or be sued. Sue, active voice, be sued, passive. Powerful level. Not the powerful level on behalf of the company, liquidity. So, first we have to get the permission, right? Which without getting the leave of the court, no one can file an action against the company. Right? The liquidator may be appointed. Like this person is appointed. Now, this is about the liquidator. Right? Liquidator. Right. Here it says the official receiver by virtue of his office. Official receiver by virtue of his office becomes provisional liquidator. Right? The reason is here it is mentioned within brackets after filing an application for winding up until the winding up order is given by the court. Right? There is a risk in allowing the directors or shareholders handling the assets of the company. Therefore, the court will appoint a provisional liquidator to displace the directors and control the business of the company until the winding up order is given. Right? And he continues to act until he or another person is appointed as the liquidator. I told you, provisional liquidator, same person or another person, because of the nomination, we have to consider nomination made at the two separate meetings. Creditors have contributed. Same person or another person may be appointed as the liquidator. Right, so until the liquidator is appointed, after the winding up order, the provisional liquidator or the official receiver monitor the affairs of the company. Right? He or another person is appointed as the liquidator. After the winding up order is issued, one or more liquidators may be appointed by the court to conduct winding up proceedings. Right? So, in order to conduct the winding up proceedings, liquidators are appointed. Winding up proceedings means collecting the assets, realize, settle the creditors, expenses, and distribute the surplus assets among the contributors. Then the winding up process. Employees of the company are dismissed. Right? We have to terminate the services of the employees. Right? Then on the appointment of the liquidator, the powers of the directors are ceased. It is terminated, right? Ceased. And after the commencement of the winding of any sale, so this is the thing that I mentioned, right? After the commencement date is the date on which petition is filed. After the commencement of the winding of any sale, right? Disposition, the hierarchy, disposition, right? Or transfer of any property or share, or any alteration with the status of the members, right? Is void, to be treated as void. This void. Right? So that happened after the winding, after the commencement of winding, right? So during that period, any sale, disposition to be treated as void. Then official receiver, another heading. Official receiver is an officer attached to the court. He is attached to the court for insolvency purposes. Or such other person appointed to the court by the minister as the official receiver. Therefore, he is an individual appointed to monitor the company for a short period in a manner that will ensure the payback the creditors. Right? So it is the same person, right? The provisional liquidator and the official receiver, same person, right? This person is appointed in order to appoint an independent party, right? In order to ensure the payback of the creditors, right? So otherwise, allowing the directors or shareholders to control the affairs of the company may be harmful to the creditors. That's why we are appointing official receiver. Duties of the official receiver. According to section 283, the official receiver has a duty to obtain a statement of affairs. Right, so there is the first statement to be obtained within 14 days after the appointment of the provisional liquidator or after the winding up order. The statement of affairs of the company must be delivered by the official, must be delivered to the official receiver by one or more of the directors and by the secretary. Or if the official receiver so requires by other person. The statement must be in prescribed form, that is form 25, and verified by an affidavit. Statement must set out particulars of the assets, debts, and liabilities of the company. These are the particulars mentioned in the statement, the assets, liabilities, and name and addresses of the creditors. Name and residence and occupation of the creditors and the securities held by the creditors, such as the information may be required. So that is the first duty, statement obtaining, statement of affairs. And the second one, official receiver has a duty to summon. Summon means call, right? To call separate two meetings of creditors and contributors in order to determine whether or not an application to be made to the court for the appointment of the liquidator. So, in order to decide appointment of the liquidator in the place of the official receiver, instead of him, another person to be appointed or not, in order to decide that. And the appointment of the committee of inspection to act with the liquidator, right? So that's why there is the reason for two separate meetings of contributories and creditors. The official receiver has to report the affairs of the company to the court. And he has to report the affairs of the company to the court. Another duty mentioned. Right. Then provisional liquidator. Provisional liquidator. Right. After filing an application for winding up of the company until the winding up order, allowing the same reason mentioned here also, right? Allowing the assets of the company to remain on the hands of the creditors, so directors or shareholders is a risk. Therefore, court may appoint a provisional liquidator or no after receiving the petition for winding up of the company, right? For the management and protection of the assets owned by the company until such time court makes the winding up order. So until the winding up order is given, official receiver is provisional is about the provisional liquidator. Provisional liquidator is appointed, right? And thereafter liquidator, that is after the winding up order. The court has power to appoint a liquidator. The court may appoint a liquidator based on nomination made after the meetings of the creditors and contributors. So after considering the nomination made at the two separate meetings of creditors and contributors, court will appoint suitable person as the liquidator. So most probably the same person, provisional liquidator, will be appointed as the liquidator. If the two meetings do not agree on the person going to be appointed, the court will decide the difference and make such order as it thinks fit. Suitable order can be made. If there is a difference between the two parties, creditors and contributors, then will make the suitable order. If the liquidator is not appointed by the court, official receiver will act as the liquidator. That is about the liquidator. Right.
ඒක වයින් ඒකට ආන්තරේ වයින් අප්ලයින් කරන්න පුළුවන්.
ඒක ක්ලවුඩ් එකක් කියලා තියෙනවා මම. ඔය විදිහේ කන්ඩිෂන්ස් තුන තියෙනවා නම්.
නෑ කන්ඩිෂන් තුන නිකන් සාමාන්‍ය හොටල් කරලා පුළුවන් කරන්නේ.
ඔව්. ඒකට වයින්ඩ් අප් කරන්නත් පුළුවන්. ඒක වෙනම ස්පෙෂලි ඒක ඔසින් ඕක ඇප්ලයි කරලා ඔය දැන් කම්පැනි යුත් කරනදානේ කට්ටිය ඒක රිකවර් කරනවා. කරන්නේ.
ඔව් රිකවර්. ඒක ඒකනෝ නොදන්නවා.
ඒක කියන්නේ DC නේ. දිසාධි කරන්නේ.
ඔච්චර ඕනේ කියලා.
ඒක දිසාධි. ඒක වෙනස්. කියන්නේ ඒක අපි කියන්නේ course of action එක වෙනස් නේ.
ඒක රිකවර්.
ඔව් රිකවර්.
කට්ටිය දන්නකෝ දුන්නා.
ඒක අපිට කොම්පැනි එක වයිඩ් අප් කරනවා කරන්නේ. ඒක GSB එකේ මේක ගන්න එක. ලේසි.
නැත්නම් ගොඩක් කලනවා.
මොකක්ද?
වයින් අප් කරන්න කිව්වොත්
වයින්ඩ් අප් කරන්න ස්පෙෂල් රීසන්ස් තියෙනවා. ඒක දුන්නා. සමහරවිට ඒ නඩු බිස්නස් එකේ පොඩි කරලා කම්පැනි ඉදිරිපත් වෙලා කියනවා නෑ අපි ඒක කරනවා කියන්නේ. බිස්නස් එකේ ඒක සාර්ථක වෙන්නේ දෙවිත් දෙවියන් කියන්නේ කරව වෙන්නේ සමානතර දැන් රිවන්ඩ් කරේ.
එහෙම නෝන. මොකද අපි ඉතර කෝගේ ට්‍රයිස්ටාර් කම්පැනි එක ලික්විඩේට් කරා. ඒකදී මෙතන කරල්ල පැත්තේ කම්පැනි තමයි අපෝයින්ට් කළේ ලික්විඩේට් කරනවා. ට්‍රයිස්ටාර්. ඒක තමයි එමයි කම්පැනි අපෝයින්ට් කරනවා.
ඒක සාමාන්‍යයෙන් වෙන්නේ අර විදිය. කරන් කවුරුහරි අර රිසර්ච් ලයින් කන්ට්‍රිබියුටර්ස් ලයින් කැමති වෙනවා නම් වෙන කෙනෙක් වුණත් පත් කරන්න.
වෙන එකක් කරන්න.
කම්පැනි එකක් පත් වෙන්න පුළුවන්.
ඒක මොකද ගොඩක් කට්ටිය වයින්ඩ් අප් කරන්න ඇක්ෂන් ගන්න රිකවරි ඇක්ෂන් තමයි ගන්න.
රිකවරි. ගොඩාක් කියන්නේ රිකවරි. ඒකේ ස්පෙෂල් රීසන් එකක්.
ඔය වයින්ඩ් අප් කරන්න කිව්වොත් ඔක අනිවාර්යෙන් ගන්න පුළුවන්.
ඔව් ඒ කියන්නේ දැන් ඒගොල්ලන්ට සාමාන්‍ය වයින්ඩ් අප් කරන්න යනවා කියන්නේ සෙට්ස් වලින් කියනවා නම් බිස්නස් එකක් නෙමෙයි. ඔය කියන හැම වෙලාවෙම බිස්නස් එක රන් වෙනවා. රන් වෙන වෙලාවෙදී අපි මුදල් ගන්නවා නිසා ඒ ඇසෙට්ස් මේ ඩිස්කස් කරලා ආයෙ ගන්න ඕනේ. ඒක අපි කො කම්පැනි එකේ මුකුත් බිස්නස් එකක් නැහැ කියන්නේ. වන් වෙන්නේ. ඉන්න එකක් නෑ. ඒතකොට විකල්ප කරන්න බෑ. ඒකෝට ඉන්නේ මේ තියෙන ඇසෙට්ස් හරි මොනවා හරි ඒවා විකුණු වෙලා.
අපේ කමර්ෂල් හයි කෝට් එක තමයි දානවා. කමර්ෂල් හයි කෝට් එකට පෙටිෂන් එකක් දානවා. ඒක විභාග කැපිටේෂන් එක දාන්න පස්සේ ඒකත් විභාග කරන්න පුළුවන් දේක බලන්න ජජ්මන්ට් එකක් දෙන්නවා නේ.
දැන් පෙටිෂන් එක දැම්මම පස්සේ අනිත් පැත්තට නෝටිස් යවනවා. ඊට පස්සේ ඒගොල්ලෝ පෙවිදලේ ඒකට විරුද්ධව ආරම්භයක් ඔබ්ජෙක්ෂන්. ඊට පස්සේ තමයි ඒ දෙකට කල්පිත කරලා අපි
සති දවස් 14 ගියා කියන එකම නෙමෙයි රීසන් එක. ඒකට
ඒ අරකට මේ රීඩින්ග්ස් ගන්නෝනේ කියන්නේ අපේ ඇප්ලිකේෂන් එක කරන්න. පෙටිෂන් එක දාන්න. මේ ලිස්ට් එක සම්පූර්ණම එයා එන්ටයිර්ලි නඩුවක් දාන්න ඒක වයින්ඩ් අප් කරන්න.
ඒකේ වයින්ඩ් අප් කරන්න නඩුව දැම්මට පස්සේ ඔපරේෂන් යන්න ඔපරේෂන් නවත්තන්න ඕනද? එහෙම කරන්න.
ඒක යනවා. ඕක එකක් ප්‍රොෆෙෂනල් ලිපිනයකට පුළුවන් මේක කරගෙන යන්න. ඒක අපේ ඕනර් එක පස්සෙත් කරගෙන යන්න පුළුවන්. ලිපිනයකට පුළුවන් යම් තාක් කාර්යයක් කරගෙන යන්න. ඒක එකපාරටම කරන්නේ. සමහර අපි කරු ඩිපොසිට් සාගාවල කරන ඒවා මැචුර් එක කාර්යයක් කරනවා. අර වගේ ඒක පස්සෙත්
අපි ගිහුව කම්පැනි වයින්ඩ් අප් කළා කියලා රුපියල් 10ක් කොටුම් ගෙවන්න තියෙනවා. ඇසෙට් වලින් 500 යාර. කරන්න දෙන්නේ. ඒකට ඩිරෙක්ටර්ස්ලා පර්සනලි ඒවට ගරන්ට් වෙන්නේ නැහැ.
ඒක නම් පිළිතුරේ මේක සර් ක්ලාස් එකක්. ඔව්.
එච්චර.
ඉතින් ඒකේ ලිමිටඩ් ලයින් එක කියන එක
නෑ අපි ඔය කේස් එක මට එක්ස්පීරියන්ස් තියෙනවා බැංකුවෙන් පර්සනල් ගරන්ටි ගන්නවා. අර යා කම්පැනි එකම ලෝන් එක දෙන්නේ. අපි ඩිරෙක්ටර්ගේ පර්සනල් ගරන්ටි කරනවා.
ඒක පර්සනල් රිසෝස්.
පර්සනල්. ඒකට අපිට ඔයාලගේ chance එකක් තියෙනවද? අපිට ලෝන් එක දෙන වෙලාවේ පර්සනල් ගරන්ටි නෑ. ආෆ්ටර් අපෝටි කාලෙකින් පර්සනල් ගරන්ටි ජොයින් කරොත් ඒකට චැලෙන්ජ් කරන්න පුළුවන්.
ඒකයි ඉතින් ඉනෝවේෂන් කියන කන්සෙප්ට් එක. ඒ කියන්නේ ක්‍රෙඩිටර් ඔය ගාරන්ටර් දෙන account එක අයත් කරනවා අලුත් කරගෙන දෙනවා.
අලුත් කරනවා.
ඕන රෙස්පොන්ස් ආයතනයේ ඒක ඔපෝස් කරන්න බෑ මේ අකටත් මේක දුන්නා කියන ගාරන්ටර්.
එතකොට අපි ලෝන් එක ගත්ත කියලා මරණම් කියනකොට ඒකට ගාරන්ටර් අස්සම් කරලා දෙන්නට රෙස්පොන්සිබල් නැත්නම් බැංකුව රෙස්පොන්සිබල්ද ඉන්ෂුරන්ස් එකේ කවර් කරනවා.
प्रिंसिपल लीडर ने
නෑ
या मैं
මම
इधर से
ඊට පස්සේ බැංකුවට එන්න පුළුවන් මේ ගැරන්ටර්ස් කතාවට. ඒ ඒකට ලෝන් එක
මේවා ඇග්‍රීමන්ට්ස් දෙකක් තියෙනවා. එකක් තමයි ගාරන්ටි. අනිත් එක තමයි ඉන්ඩෙන්ටි බොන්ඩ් එක. සාමාන්‍ය බැංකුවක් දාන ඉන්ඩෙන්ටි බොන්ඩ් එක. ඉන්ඩෙන්ටි බොන්ඩ් එක කියන්නේ ඒක ප්‍රින්සිපල් එක දැන්
ඇතුළට
එදිම ආවයගෙන් මේ
අය කරගන්න
නමුත් ගාරන්ටි කියන එක ගාරන්ටි කියන්නේ ඇතුළත තියෙන රෝමන් ටැක්ස් වල ඒ ගාරන්ටි එක කියන ප්‍රිවිලේජස් තුනක්. ඒක තමයි ගාරන්ටි කියන්නේ ඒ කියන්නේ ප්‍රින්සිපල් දැන් අපි කරමු මම ගන්නවා කියන්නේ මම ආවගෙන යා දේවල් ඒක ඩිෆෝල්ට් එක. ඊට පස්සේ ක්‍රෙඩිට් එකේ එම්ප්ලොයර් කවුරුත් ක්‍රෙඩිට් ඉස්සෙල්ලාම මම ගත්ත දෙකකට විදුණු නඩුදාර අර විදිහට එක්සිකියුට් කරන විදිහට බලනවා ලෝන් එක කියන්නේ අයරේ ඒකට ගන්න පුළුවන් අපි ලක්ෂ 10යි අය කරගත්තේ ලක්ෂ 8යි ඊගාව ලක්ෂ 2යි කරගන්න තමයි ගැරන්ටි එක විදුණු නඩුදාර
එතකොට ඒ ප්‍රින්සිපල් මැරුණට පස්සේ එතකොට ගැරන්ටර්ස් වලට කියන්න පුළුවන් ප්‍රින්සිපල් දැන් මැරලා එතකොට අයි එක ඒගොල්ලන් ඉන්ෂුරන්ස් එකෙන් ක්ලේම් කරගන්න බෑ.
ඉන්ෂුරන්ස් එක ඒක බලන්න ඉන්ෂුරන්ස් එකේ මොනවද
ඒ අනිවාර්යයෙන් ලෝන් එකක් ගන්න ඉන්ෂුරන්ස් එක අනිවාර්යෙන් ලයිෆ් ඉන්ෂුරන්ස් එක අනිවාර්යෙන් දාන්න බෑ. එතකොට ලයිෆ් ඉන්ෂුරන්ස් එක දැම්මම පස්සේ ලයිෆ් ඉන්ෂුරන්ස් එක නේ එතකොට තියෙන්නේ අපිට පාරි ඉන්ෂුරන්ස් එක ෆුල් ඉන්ෂුරන්ස් එකක් දැම්මම වගේ එතකොට
ඒක ඉන්ෂුරන්ස් කියන්නේ ටයිටල් ඉන්ෂුරන්ස් එකක් වගේ
ටයිටල් එකේ නේ ටයිටල් ඉන්ෂුරන්ස් එකක් આવුත් ටයිටල් ප්‍රශ්නයක් આવුත් එහෙම නැතුව පර්සනල් දැන් අපි
ඒකට කියනවනේ
වෙනම එකක් දාන ඉන්ෂුරන්ස් එක පර්සනල් ඉන්ෂුරන්ස් එක.
ඒක ඉන්ෂුරන්ස් එකේ විකාශය කරන්නේ
නැහැ දැන් අපි ඉන්න අනිත් කට්ටිය පස්සෙන් එනවා බැංකු මම කියලා දෙපාරක් බැංකුවට කතා කළා මැනේජර්ලත් ඒක උත්තර දෙන්න බැරුණා.
අනිවාර්යයෙන් විකාශය
විකාශය
මොලොක් කියනවා කියලා
ඔව් ඉන්ෂුරන්ස් එකට දැන් කපන් තියෙනවා සල්ලි. ඔයගේ තියෙන ඉන්ෂුරන්ස් එකක්
ඒක යාමලා කියලා ඒතර ඉවරයි ඉන්නේ. ඒ කියන්නේ ආගේ මුදලේ අර දීපල් මොනවා කරලා තියෙනවා. ඒගොල්ලෝ ඇක්ටලා නඩු යනවා.
ඒ කියන්නේ බැංකුව නඩු දානවා.
ලියනවා. එයාගේ යාස්ලා රිස්පොන්සිබල්. වයිෆ් ඉන්නවා ළමයි ඉන්නවා ඒගොල්ලන්ට ඇක්ටලා ඒගොල්ලන්ට නඩු යනවා.
නඩු දානවා. ඒක පර්සනල් ගැරන්ටි එකක් තියෙන එක දිගට ගන්න. අපි පර්සනල් ලෝන් එකක් කරගෙන යාගේ EPF EDF එකක් තියෙනවා ඒකින් හරි ගන්න පුළුවන් වෙනවා නේ.
EPF EDF නඩු කරන්න බෑ එක්සිකියුෂන් ලෝන්.
නෑ.
ඒකේ පර්මිෂන් වෙන කරන්නේ.
අයියන් මගේ පර්සනල් ඩෙට්ස් වලට මගේ EPF EDF වලට
ඒක
ඒ ස්පෙෂල් එකක්.
ඒ රෙද්ද පඩිය අර්ථකාරී මාර්ගයක් කර කිතුති තමයි. අතාරිනේ වගේ තියෙනවා. මම පරිචයලා ඉන්න එකම දේ නම්
ඒකක් දෙන්න.
ඔව් ඒකත් අයින් කරනවා. ඒකයි කරන්නේ කරලා. ඒ වෘත්තිය කරගෙන යන අවශ්‍ය කරන උපකරණ.
අයින්
කරලා ඉතින් ඒක නම් පුරුදු විසාරවල වැඩ නැහැ. ඒවා තමයි සීස්ත්‍රි. විකාශ කරන්න බලන්න.
දැන් මේ ලංකාවේ පර්සනල් ලික්විඩිටර්ස් කියන්නේ ප්‍රොෆෙෂනල් ලික්විඩිටර්ස් ඉන්නවා. ඒ කම්පැනියක් විදිහට දැන් ඒක ලෝ එකෙන් විතර.
ඔයස්ලා නෙමෙයි ඉතින් අතර ඔය ඒකේ එක්ස්පර්ටිස්ලා නැහැ අතනම් බලනවා ලංකාවේ වෙන්කර් කියලා නේද. ඒ
ලෝ එකේ දැන් කම්පැනි සෙක්‍රටරි ඇඩ් කරනවා ලෝ එකේ ඇඩ් කරනවා කම්පැනි සෙක්‍රටරි. ඒ වගේ ලික්විඩේටර්ස්ලා විදිහට ස්පෙෂල් කවුරු ඉන්නවා ලංකාවේ. ඇකවුන්ටන්ට්ස්ලා හරි.
ඒක මොකක්ද නෑ ඒක highlight වෙලා ඔය කරනවා ඒක
ෆාම්ස් ඒ ෆාම්ස් අනිත් කරත් කරනවා මේක කරනවා. ඒකෝට ලික්විඩේටර් මොකක් බෙනිෆිට් එකක් ගන්න පුළුවන්ද? ඒකෙන් කමිෂන් එකක්
ගන්න. ඔව් ඒ යාට මොකක් කර රිමිනරේෂන් එකක් දෙන්න ඕන.
කම්පැනි.
යනතරේ යා මොකක් කියනවා. ඉතින් මොකද දවස් දෙකේ සමානලා ටිකක්
යනවා. මොකද නාමලේ ටයිස් ටාගල කම්පැනි එකකින් මොනවද? මධ්‍යයකට ඊට පස්සේ වගේ උනේ ඒ ඇසෙට් ටික වික්කට පස්සේ ඔක්කොම සෙල් කරලා පස්සේ තව ලක්ෂ 7යි ගාණක් ගෙවන්න. ඒකට ඉතින් පර්සනල් නඩු දානවා. රයිට්.
ඔය ඒක තමයි. ඒක තමයි මොනවද?
ඒක කම්පැනි මේ ලයිබිලිටි නැති වුණාට මේගොල්ලෝ කොහොමද අපෝ පර්සනල් නඩු දැම්මා ඩිරෙක්ටර්ස් වලට.
ඒක තව මොකක්ද ඇති?
ඇති මක් කරේ නෑ සප්ලයර්ගේ පර්සනල් ගැරන්ටිලා වඩු ගන්නන්නේ මොකක් කරේ ඇති. මේ කම්පැනි එකට මෙහෙම ඇයිද නැත්නම් මේක චේන්ජ් වෙන්නේ?
ආවොත් පොඩි පොඩි වගේ තමයි ඇවිල්ලා තියෙන්නේ. ඒ කියන්නේ අවුල් නැහැ. කම්පැනි සෙට් එකේ සාමාන්‍යයෙන් ප්‍රශ්න අඩුයි. what changes and over and ඒක පොඩ්ඩක් ස්මූත් යනවා මේ.
ඒක නෙමෙයි කියන්නේ.
ඒක මම අනිවාර්යයෙන්ම සාර්ථක අපරාධ පොඩි පොඩි ඒවා තමයි. ඒක තමයි.
ඔය මේ ඇනුවල් රිටර්න්ස් ෆයිල් කරලා නැත්නම් කම්පැනි අවුරුදු සාමාන්‍යයෙන් 5යි. මොකක් හරි ප්‍රිවිලේජ් එකක් තියෙනවා ඒ කියන්නේ මේ ඇනුවල් රිටර්න් ෆයිල් කරලා නැහැ. මම කරන කම්පැනි එකේ ඇනුවල් රිටර්න් අවුරුදු 7ක් තිස්සේ ෆයිල් කරලා.
ඒක මේ දෙනවා ඇක්ටිවිටි එක. සමහරවිට ගේම් එකක් තියෙනවා ඒක මේ ෆන්ක්ෂන් එක වෙන්නේ කියලා.
මේ බැංක් ස්ටේට්මන්ට්ස් අරන් දෙන්න ෆන්ක්ෂන් වෙලා තියෙනවා. ෆන්ක්ෂන් වෙලා තියෙනවා ඒගොල්ලෝ ගෙවනවා. මේ කියන්නේ සමහර
සමහර අය නම් ඒක රෙජිස්ටර් කරලා
ඔව් ඒකවා.
ඇක්ටිවිටි එකක් දීලා ඒක හෝල්ඩ් කරනවා. ඒක තමයි ඒක කරලා
නෑ මොකද ඒක දිනන නිකන් ඉන්නවට පාම නෝට්ස් ෆයිල් කරලා දෙන්න අවුරුදු 3-4ක් විතර ෆයිල් කරලා මොකද නෝට්ස් එල්ලත් නෑ ආරෝස නෝ සාමාන්‍ය නෝට්ස් එක එන්න ඕනේ නෝට්ස් එක කරගෙන පැනල්ටි එකක් මෙතන ගන්නවා 50යි ඊට පස්සේ වැඩි වෙන දවස් අවුරුද්දකට ආයි 50,000 ගන්න දුර ගන්නවා ටෙක්නිකලි
රයිඩ් අප් කරන්නේ නැතුව ඒකට ඇග්‍රීමන්ට් එකේ තමයි ඇවිත් තියෙනවා.
එහෙමත් තියෙනවා.
ඒව මොකක්ද කරලා දැක්කේ
එහෙමත් කරනවා.
ඔය
ඒක අර සිටුේෂන් එක වෙනස් වෙනවා.
නීතියම මේකත් අර ඒ දාසේ නගෙන සිරිත් අරවගේවත් තියෙනවා පුරුද්දක් කියනවා කියනවා.
අනිත් වෙනස් වෙන්නේ. Thank you.
හැමදාම එහෙම
ඔව් හැමදාම
මේක වල තියෙන
ඔව් දැන් නැත්නම් එහෙම කරන්නේ.
මේක වල තියෙන සාකච්ඡා කරනවා රූලට අකුරු ප්‍රමාණයට සාමාන්‍ය මිනිස්සු. ඒක
මොකද නිකන් දිනවා.
ඒක අපේ රයිට් ඔෆ් කරලා
රයිට් ඔෆ් කරලා
රිකවර් කරන්න බෑ. හරි. Right. Now, after liquidator, then the qualification of a liquidator. So these persons cannot be appointed as a liquidator of a company, right? So other than these parties can be appointed as the liquidator, minors, right? That is very obvious, right? Credit of the company 2 years immediately before the commencement date of the winding up. The person who is a shareholder, we have to consider 2 years immediately. If he is a shareholder, director, auditor, receiver of the company or related company cannot be appointed as a person who is prohibited under 468. Actually, 468 it says official receiver who has breached his duties seriously cannot be appointed as a liquidator of the company. Right? It's a disqualification. Right? 468, section 468. Official receiver, it refers to the official who has defaulted his duties seriously. What are the duties tasks of the official receiver? Right? Obtaining statement of affairs and yes, two separate meanings of creditors and creditors. So these duties are seriously violated by the official receiver. Then it's a disqualification to be appointed as an official receiver. And person who is prohibited from being a director or a promoter under section 230 240. 230 240 we have discussed under qualification of the directors. What are the 230 it says after conviction or adjudication that person cannot be appointed as a director or promoter of a company for a period uh, of 5 years. Restriction go for 5 years. 5 years, right? Then 214 says by an order of the court, some persons can be restricted from being appointed as a director or promoter of a company for a period not exceeding 10 years. That is 214, 213, sorry, 213 and 214. Right? So, if a person who is prohibited under section 213 and 214, same person also cannot be appointed as a liquidator of the company, who is prohibited from being a director under the former Companies Act. So this is number 17 of 1982, right? He is a director prohibited from being a director under former Companies Act and who has adjudged to be of unsound mind. So actually when we consider 230 unsound mind, that type of persons are already included to the 230. Right? Specifically here mentioned again, who has been adjudged to be of unsound mind. Minors, unsound mind, they cannot be appointed as a liquidator. That is a obvious, right? Unsound mind cannot be appointed, right? So, powers of the liquidator. So these are the powers: sue or be sued on behalf of the company, and carry on the business of the company so far as may be necessary for the beneficial of the company, to appoint attorneys at law, these lawyers, to assist him, to pay any class of creditors, right, to make any compromise with creditors, and negotiations he can engage into negotiations with creditors, sell movable and immovable properties in public auction, to execute deed, that means sign deed, receipts and other documents, draw, accept, endorse any bill of exchange or promissory note on behalf of the company, like checks. Checks are also included to the word bills of exchange. Right, so he has powers to perform these, right? Then committee of inspection, right? We have discussed that, right? The committee of inspection is appointed by the court. This committee consists of a small number of creditors and contributors. And its functions are to assist the liquidator to inspect and certify the accounts. If there is no committee of inspection appointed, the court will exercise the power of the court. So there is about to inspect and certify the accounts of the company. That is the main function of the committee of inspection. That is about the compulsory binding. Understood? Right. Then we can move on to, now actually there are three modes. Right. First one we have discussed, compulsory, voluntary binding. Right. So here voluntary means, right, in consent of the shareholders, right? That the consent is given by the shareholders in order to wind up the company. And if the article provides for the dissolving of the company after a specified period, or on the occurrence of a specified delay, or after a specified period, after particular date, on occurrence of particular acts, then it is mentioned in the article, then after happening that, or after expiry of that period, the company can wind up. The company resolve a special resolution as to the company should wind up voluntarily. So these are some grounds for voluntary wind up. If the company cannot continue its business by reason of its liabilities. Right? Appointment of the liquidators in a voluntary winding up. Actually, who has the consent of voluntary means in consent of the contributors. Company is going to be liquidated. Right? So liquidators are appointed by who? Contributors, shareholders. At the end of meeting, the company at a general meeting, right? At a general meeting shall appoint one or more liquidators to wind up the company by voluntary. Right? On the appointment of the liquidators, the powers of the directors shall cease. That is happening after appointment of the liquidator. Same thing we have discussed, right? So once the official is appointed, then the powers of the directors are ceased. Right? Here we have to appoint the liquidator. Actually, now here we don't have these positions: official, receiver, and provisional liquidator. We don't have. It's voluntary winding up. With consent of the shareholders, they decide to liquidate the company. They appoint the liquidator. Now, here, liquidator is appointed by the board, right? But here, if it is a voluntary winding up, liquidator is appointed by the shareholders, right? There are two types of voluntary winding up. Shareholders voluntary winding up and creditors voluntary winding up. Right? Shareholders voluntary winding up and creditors voluntary winding up. Actually, this is depend on particular declaration. This is known as a declaration of solvency. Right? If the company able to receive this declaration is known as declaration of solvency. If the company able to get the declaration of solvency, then it becomes shareholders voluntary winding up. Unable to get the declaration of solvency, it becomes creditors voluntary winding up. Right? So actually here declaration to be given by majority of directors by passing a resolution at a directors meeting, right? Then they have to set out in the declaration. They have gone through all the affairs of the company, right? They have inquired into all the affairs of the company. And the second thing, they have to mention, according to their opinion, right, the company can settle all the creditors in full, right, within 12 months after commencement of the winding up. So if this declaration is given by the directors, then it becomes shareholders voluntary winding up. Unable to give that, creditors voluntary winding up. Understood? There are two types of voluntary winding up. Right? So here we can go through that. Right? When a declaration of solvency is made, what do you mean by solvency? Solvency and insolvency. Solvency means able to settle the debts. They can have a single Rugunna. Rugunna Bhave Prakash. You know, we can't do that. Rugun, we can Bampolo Nagina Prakasha, Rugun Tama, a shareholders voluntary winding up that way. That's why they are the again, Bampolo. Then it becomes creditors voluntary winding up. Right? Declaration of solvency is made, then it becomes shareholders voluntary winding up. When such is not made, then it becomes creditors voluntary winding up. So declaration of solvency. Declaration is made by a resolution of the majority of directors at a meeting of directors. Board meeting, it will be passed as a resolution by majority of directors, and they have to state directors have made a full inquiry into the affairs of the company, and they are of the opinion that the company, right, of the opinion that the company will be able to pay its debts in full within a period of not exceeding 12 months from the date of commencement of the winding up of the company. The company able to pay the debts of creditors in full within 12 months from the date of commencement of the winding up. So this is the declaration to be given by majority of directors. It is known as declaration of solvency. This declaration takes effect only on registration with the registrar company. Government mentioned in it. Right? So it depends on this declaration of solvency. Then we discussed about three modes. Right? So voluntary winding up. Then the third mode is winding up subject to supervision of court. Right? Winding up subject to supervision of the court. Right? Here what happened actually, right? The company passed a resolution for voluntary winding up. There is a subcategory of voluntary winding up. Resolution passed as to wind up the company voluntarily. Then what happened? Creditor or a shareholder make an application to court, right? Right, by seeking an order. What is the order? Order is wind up the company voluntarily, but subject to supervision of the court. Right? So, උසාවි අධීක්ෂණය යටතේ ස්වේච්ඡාවෙන් විශ්වාසයෙන් කියන ඊළඟ කරනවා. When such order is granted, then it becomes right subject to supervision of court. Why become subject to supervision of court? Right? It is a subcategory of voluntary winding up. So a company passed a resolution for voluntary winding up. A petition may be made to court by seeking an order that the voluntary winding up shall continue subject to the supervision of the court. Right? Subject to supervision of the court. Right? The court can supervise the winding. This application may be made by creditors or contributories or others. So basically, you can identify creditors can make this application to court. Wind up voluntary but subject to supervision of the court. That is about the winding up subject to supervision of court. That's all. Sally, විවිධාදී ප්‍රශ්න කරේ බලන්න මේක ඔයගොල්ලන්ට කොහොමද මේක දාන්න කොහොමද මේක අප්ලෝඩ් කරන්න බෑ. Second question, Gamma Limited is a public company duly incorporated under the Companies Act. Recently, due to some reasons, the company is facing serious financial difficulties. Accordingly, last week, the company defaulted to pay Mr. Silva, the creditor of the company. Now, Mr. Silva is seeking the possibility of recovering his money by dissolving the company. Right now, agree, right? There are two types of cases can be filed. One is in order to recover money. Now here, Mr. Silva is right. Mr. Silva is going to recover the money by winding up of the company, right? By dissolving the company, required to outline the steps of compulsory winding up of the company. Advise Mr. Silva. So what are the steps? Steps are these. Right, file a petition along with an affidavit. That is the first step. Official receiver will be appointed. By virtue of his office, provisional liquidator is appointed. And winding up order is given. Right, so effective date is the date on which petition is filed. Then thereafter, liquidator is appointed. 5 steps we can identify. Now, how we can give advice to Mr. Silva? Actually, whether he is entitled to file an action in order to liquidate the company. Yes. So, Janapriya Prashna. Now, how we can decide whether Mr. Silva is entitled to file an action for dissolve the company? Now he is seeking the possibility of recovering his money by dissolving the company. What are the conditions to be fulfilled in order to file an action in order to dissolve the company? Right? So these particulars are not actually specifically given. Right? Amount we have to consider. Right? The amount falls to the creditor. It is very critical. And thereafter we have to consider whether there is a written request. Written request. It is not given. And after the written request, how much of time we have to allow for the grace period? 3 weeks time. So within 3 weeks time, if the company defaults to or neglect to settle the credit, settle the money, then creditor can bring an action for dissolving the company. Right? So these are the requirements to be fulfilled. Right? අපි ඒකට පුන නියම බලමු ලියමු. කොහොමද අපිම ටිකක් දවසක් ඉතින් අපි මොකද දෙයන්නේ 10 පහක් තියෙනවා. දෙකේ පොඩි ඉතුරු පාඩම් දෙකක් තියෙනවා ඒක ඉවර කරලා පොඩි ඩිවිෂන් එකක් කරන්න සහ ප්‍රශ්න ටිකක් කරමු මොකද මගේ ප්‍රශ්න ටීම් එක ඉවර කරනවා කාම දෙන්නේ. ඒක ප්‍රශ්න ටිකක් කරමු. අන්තිමේ අපි පාස් පේපර් එකක් කරමු. මොඩල් පේපර් එකක් කරමු. ඒක ඉවර. තව ඔය නෝට්ස් වල සම්පූර්ණ තාපික පොඩි සමරි එක. සමරි වෙනකන් මම ඒක ඉවරනවා තමයි. මොකද කියනවා මේ කලින් අප්ලෝඩ් කරන්න කියන්නේ මේක බලා ගන්න. ඒක ඔය කටපාඩම් කරන්න දෙන්නේ. ඒ කියන්නේ එක ටොපික් එකක් එක පේජ් එකේ. A4 size එක පේජ් එකේ තියෙනවා. තමයි බලා ගන්න තියෙන්නේ. ඒක පිටුවර එකයි. ඒක නාමයක් තියෙන ඒක බලා ගන්න. මෙතනින් පස්සේ අපේ ඇතුළේ කම්පැනිස් ඇක්ට් එකේ තියෙන ඒවා ඉවරයි. ඊට පස්සේ අපිට තියෙන්නේ ෆොරින් එක්ස්චේන්ජ් securities කියන පාඩමක් තියෙනවා. ඒකයි laws adjacent to company law කියලා තියෙනවා. Foreign exchange act එකයි prevention of alienation of lands කියලා මේ act එකක් තියෙනවා. මේ දෙක කතා කරලා එච්චර. ඊට පස්සේ company sector එක මෙතන ඉවරයි. වයිඩින් අප් විසුවාලිය පටන් ගන්නවා ඉස්සරහට. ඒක දෙක කළා. 2003 අපි අද අලුතෙන් පෙරවරගේ ඉන්නේ ප්‍රොවිෂන් එකක් කරලා ඒක පාලනය කරගන්න පුළුවන් අද ඒකම දාන්න. ඔයාලා පාලනය කරලා ඕගොල්ලන් ගාන ලෝකෙ දාන්න. සබ්ජෙක්ට් නම්යක් තියෙනවලුනේ. මම ඒක දානවා ඒකේ පාලනය කරගන්න දෙන්නේ. ඒක සමරයක් තියෙනවා ඒක අර ඉක්මනට බලා ගන්න. මොකද වෙන්නේ? right hari මේකේ අපි කොහොමද ලියන්නේ advice Mr. Silva මේව අපි දානවා in order to wind up the company by a creditor he has to satisfy the board. He has to satisfy the board that the company is unable to pay its debts. Is unable to pay its debts. Right? We can say in order to company deal, in order to company deal to in order to company deal in order to company deal to be unable to pay. Deal can select deal to be unable to pay its debts. The creditor has to prove three conditions. Number one, the company owes 9 owes of the creditor more than 50,000 rupees. More than 50,000 rupees. Number two, the creditor has demanded the money. Creditor has demanded the money in writing. In writing. 3, within 3 weeks time, the company defaults or declares to settle the money, settle the credit. Settle the credit. And so that is the advice can be given to Srilanka. So we don't know whether the amount and whether the request made by Silva and the company neglects or default to pay the money within 3 weeks time. We don't know. Only the advice can be given, right? Vegabalam. Sampai campus lagi paper lagi di mereka. Budak saya dia lihat. Lihat. Mereka oh dia Allah kan fill in the blanks by using suitable words and application to wind up the company by the court shall be made by way of a petition along with supporting the facts by an affidavit. Petition and affidavit to the fact. After application is made for the winding up by court, the court will appoint, right? Who is appointed? Court will appoint an official receiver. What law that take up? An official receiver, right? He or she is an officer attached to the court, and by virtue of his office, he may be appointed as the provisional liquidator of the company until the winding up order is given by the court. After the winding up order, the court may appoint after the winding up order, the liquidator. It was the first thing we have to liquidator to conduct the winding up process. If not, will act as the if not official receiver will act as the liquidator, to conduct the winding up process. Right? If the liquidator is not appointed, then official receiver will act as the liquidator. Right? We would have done right. Wherever they are the commencement date of the winding up by court is the date of filing of the petition. Right? After the commencement of winding up, any sale, disposition, or transfer of any property to be treated as void value, right? Right? Void. The correct word is void. Then thereafter, the duty of committee of inspection is to inspect and certify the accounts of the company. Easy. Understood? So,